Good afternoon, and welcome to Marshall, Parker, and Weber's webinar called Do I Need Both a Power of Attorney and Executor? I'm Certified Elder Law Attorney Tammy Weber, and I'll be speaking with you today. I'm looking forward to it. Thank you for joining us. Just so you know, everybody's situation is different, so some of the things I'm going to talk about today are general. So we need to just keep that in mind. So let's look at the legal documents first. If we're talking about do you need a power of attorney and an executor, we need to understand what those documents are and who it is that we should choose. So a power of attorney is a legal document that you sign. It's written. There needs to be some witnesses and notarization where you name an agent, meaning somebody to do things for you. Generally, the authority that you give in a power of attorney ends when you die, and then the executor takes over. The executor is typically named in your last will and testament, which is another legal document that needs witnesses and a notarization that you sign, and you choose the person who's going to handle your estate after you pass on. So let's look a little bit deeper at a power of attorney. There are two different kinds in the way that Marshall, Parker, and Weber handles things. Different attorneys have different approaches. We like to do one for finances, so a single document that deals with financial powers, and a single document that deals with healthcare. That healthcare document would cover three things, which we'll go over in a second. So when you sign these documents, when you have a financial power of attorney, you're going to have a choice. One is, do you want it to be springing, which means although you sign it and you have the witnesses and it's notarized, it cannot be used until there's a letter attached by a physician that says you're no longer able to handle your financial affairs for some reason. It may be a short time. So say, for example, you were to have a car accident and not be able to handle things for a while, and you needed somebody to handle your financial affairs. So a letter from the doctor will be written and then attached to that document, and then your agent would take your power of attorney document to the financial institution or wherever it was the business needed to be transacted. When you regained your competence, you'd have to reverse that process and get a letter from the doctor to attach that says, now you're fine, you can handle your finances, and go back to the same financial institutions and let them know. So there could be back and forth over your lifetime, and it could cost some, and typically when those things happen, it's a crisis. So you don't really want your agent worrying about going to see the doctor and the like. I rarely will do those, but sometimes it does apply in a situation. And the other kind of financial power of attorney is immediately effective. So when you sign it and you have the witnesses and it's notarized and your agent signs the acknowledgement, it can be used, but you just tuck it away for when it needs to be done. So the second type of power of attorney is the healthcare power of attorney, which by definition is springing. So if you choose your spouse for an agent, he or she cannot use that power to get things changed for you unless the physician sees you. So it's by definition springing. The way we write our power of attorney is to cover three areas. One is HIPAA. We've all had to do those HIPAA releases when we go to see a physician. If you didn't know and were curious, HIPAA stands for Health Insurance Portability and Accountability Act from 1996. It allows people to get your information. They can't make decisions, but they can have an understanding of what's going on with you. So healthcare power of attorney could have a HIPAA release portion. It would have treatment decisions. So again, in the car accident example, If you are in extreme pain or unconscious and the doctor makes a recommendation and gives you the plus and the minus of that recommendation and you're unable to make it, you're not going to die. It's just a treatment and a timing decision. That would be the second area of the healthcare power of attorney. And then the last part of the healthcare power of attorney addresses end of life decisions. So some people do a separate document for this called a living will or an advance directive or a post form or some of the other options. But this would be when a physician or another physician, some people like to have at least two physicians make a certification that they have an end-stage medical condition or they're permanently unconscious. So when that occurs, so your agent doesn't make that decision, the doctor says you can't make treatment decisions right now and you're at the end of your life, then here's what your philosophy is. I don't want CPR, I do want CPR, or I want to just be kept comfortable at the end of my life. So let's go back in more detail to the financial power of attorney. So the law that we're currently experiencing and dealing with in Pennsylvania is called Act 95, and that applies to any financial powers of attorney that are assigned on or after January 1st, 2015. So about 5 years or so into it. And it lists certain duties. So if you're thinking about, boy, do I need a financial power of attorney? Who should I choose? The duties are that your agent has to act loyally for you, keep their assets separate from yours, act with care, competence, diligence that you would with another person and another agent in a similar circumstance. Keep a full and accurate record of anything that the agent's done, so receipts, disbursements, transactions, and preserve your estate plan. And by that I mean if your agent is your child and your estate plan is to have everything go to your spouse, your agent is not giving your money to your next door neighbor or your best friend. That means preserve the plan. Also in Act 95, the legislature said if when you write a document signed on or after January 1 of 2015, if you want your agent to have certain powers, you need to be explicit with them. And we've dubbed them the hot powers. So some examples would be to create or alter a trust that you've established during your lifetime, making gifts. So we often call this unlimited gifting, transferring money or property from you to your spouse. Often it's for a purpose to qualify for medical assistance. Sometimes it's for a purpose to keep consistent with a pattern of giving to your children or other beneficiaries during your lifetime. Another hot power would be creating or changing rights of survivorship. So if you own something and add on somebody else to own it when you die, change your beneficiary designations on a life insurance policy or an annuity or the like. Delegate authority under your power of attorney. Disclaim property. So if you inherited something from somebody and it really was worthless, it was worth less, it's going to be more problem than the benefit, they can disclaim it for you. And exercise what's called a power of appointment in your trust. Those are the hot powers. Act 95 also said, if you want to, you can waive some of these duties that are listed in the legislation. So if you want your agent to not have to handle all of those rules, you can waive them. An example might be if your agent is your spouse, you may not want to require your spouse to keep their money separate from yours. Often married people have joint accounts. What if you don't have a financial power of attorney, or the agent that you've listed refuses to act, or they passed on, or they're no longer competent? Well, there is no default law in Pennsylvania to automatically say, here who gets to handle your finances for you. So the alternative would be, if there is no document, that your loved ones or somebody familiar would have to petition in the local orphans court in the county where you live and ask to be declared your guardian. This takes some time. It's more costly than doing a financial power of attorney document, and the physician has to testify by affidavit, sometimes in person, that you're unable to handle and make decisions for your finances or otherwise. So it does take some time. And again, if the reason that this happened is because of some type of healthcare crisis or a car accident, it's really not what you want your family to have to be doing. So we're always a fan of plan ahead. Let's talk about the healthcare power of attorney. So the duties, as you can imagine, are, make decisions, healthcare decisions, research them, understand them, get the recommendation of the doctor, and make those decisions consistent with what you want. If there isn't a healthcare power of attorney, or they passed on, or they refuse to act, there is a statute in Pennsylvania that's been around since the end of January of 2007, and it's called Act 169. So it was really great when it came out because many people did not have a document, but bear in mind what Act 169 says may not reflect the wishes that you would want. There's a list of default decision makers, and there are some restrictions on end-of-life decision making. For example, if you did not have a healthcare power of attorney or a living will or an advance directive, and you were at your end of your life, people could make the decisions to maybe, for example, discontinue a ventilator and the like. But under Act 169, if you don't have a document, your default agent will not have an option, so I'm going to do a double negative here, sorry, to remove a ventilator, to remove tube feeding and hydration. In other words, if you're at the end of your life and you don't have a document that talks otherwise, you will get tube feeding and hydration, which could prolong your life. And if that's not what you want, plan ahead, get the appropriate document. So here's the pecking order, if you will, if you don't have the document. So the priority with descending order is your spouse and the adult children that are not the children of your spouse. So perhaps you had a prior relationship or a prior marriage and you have one or more adult children, but you've been currently married to your spouse for a very, very long time. They both would stand in the same shoes to make decisions for you. And then it would go, if you didn't have your spouse, it would go to your adult children, parents, siblings, grandchildren, close friends. And when we say adult in Pennsylvania, that means 18 years or older. If there's more than one person in the class, so in other words, if you're on a second relationship or you have relationships, adult children from a prior relationship, say you had two and you've been married to your current spouse for 30 years, then your two adult children could actually outvote your current spouse. So, and if it's 1 and 1, or then there's no decision until the disagreement is resolved, which is not a good thing when you're dealing with healthcare decisions that can very easily be emergent. And just keep in mind, sometimes we'll hear, oh, the hospital knows me, I've been around a long time, they know their family. Usually these days, healthcare services don't recognize family or choice in medical decisions. So, how do you choose an agent? Well, we could have lots of slides about this. There are many considerations. You could, most people usually select their spouse or a relative. You can pick whomever you want. But what you do want is somebody that's going to represent the decisions that you can make if you're able. So probably want a personality that's assertive, but not abrasive. You don't want somebody bombing through the halls of the hospital saying, you must do this, I'm the agent. That could easily turn off the people that are treating you and trying to get you better. But on the other hand, you don't want your agent to back down to somebody who's just not happy with having to do something that they're asking. And when it comes to healthcare, you don't want to choose your child or your loved one that's squeamish about even just walking into a hospital. Not a good choice. Look at whether they have healthcare or financial savvy. Do they know how to ask the right questions? Can they do research on various types of medical procedures, prognosis, and the like, and work with a trusted physician? Are they articulate? Are they calm and able to communicate clearly under pressure? If you've seen them experience a little bit of a freak out trauma response to, a cut that's bleeding, might not be the best healthcare person for your agent. Are they trustworthy? Character, values. Are they willing to serve? Some people don't want to. Do they have tough shoulders? So if what you want is, if it's the end of your life, you just want to be kept comfortable, and you're not able to make that decision at the end of your life, and your agent is doing it for you, are they going to be able to stand up to maybe other people in your family who want to just keep you alive, even if it requires lots of machines? So they have to have tough shoulders. And with healthcare decisions, proximity is important. Are they geographically close? Because as I said, healthcare decisions can also be emergent. Even though, and having discussions and talking about this is really the best way to do it. And if you want a little device, a question and answer quiz that we have, please email us at webmail@paelderlaw.com, and we'd be happy to send it to you. Or you can go to our website at paelderlaw.com. But you want to know, even if your agent doesn't agree with everything you want, that him or her, they would be able to exercise and make those decisions for you. So say you've passed away, your power of attorney has no longer any force, but there are things that are going to be wrapped up. You have assets that you've accumulated during your lifetime. So that's where your will, last will and testament, comes into play, and that lists who inherits your assets that are in your name alone. Typically, it will be personal property or vehicles, real estate that you don't own with somebody else, investments that aren't owned with somebody else and don't have designations on them. So you pick your executor. And I suggest you should name some successor executors as well. We're often asked, well, what if there's no will? Or if the named executor isn't alive, they're not willing to act, what happens? Well, there's an administrator. So instead of the word executor, somebody would administer your estate. The administrator is appointed under the Probate Estates and Fiduciaries Code. We call it the PEF code. And priority is granted to people that are entitled to your residuary estate under your will. So in other words, if you had a will and your executor, there aren't any executors that are able to act, priority is given to who's receiving your residuary estate under your will. And then the next is in list is your surviving spouse. And then there's a process in the PEF code that the Register of Wills actually has what we call quasi-judicial authority. They can either, if necessary, conduct hearings to determine who should be appointed as the administrator. And they look at the residuary estate, they look at if there's a surviving spouse, and then it goes to who would be entitled to inherit under the intestate law, meaning there is no will in Pennsylvania. And then they give preference to the size of the shares of the people that would be entitled to inherit. And then the next level would be creditors, if there are other fit persons, so it's very general. If somebody renounces and gives another person an option, that could be your executor, followed by a guardianship agency as a possibility, and the last being a redevelopment authority. So as you're thinking about an executor, what are the duties? So again, same with power of attorney, lots of duties. We're just going to hit the high points. So they're to follow the will, marshal and safeguard the assets. So if you lived in a home and you passed away and nobody else lived there that jointly owned it with you, you might want to at least find out if there are keys out there. And in some cases, it's important to just change the locks, because the executor is the one that has to answer to the beneficiaries if something gets stolen or lost, etc. The executor also has to give notice to the beneficiaries under the will, to children if they're not named, and to people who would inherit if there is no will, if they died intestate. And the executor also has to find out date of death values for the assets, because that's how the state of Pennsylvania determines the amount of inheritance tax, if any, has to be paid. Now, often, and most often, an executor hires an attorney to help with this process. The executor also, with giving the notice to the beneficiaries, puts notice in the paper. So if there are creditors out there that money is owed to, they have to be paid if there's money. And if, when you passed away, you were receiving government benefits under the Medicaid or medical assistance program, one of the executor's jobs is to write a letter to the state and say, hey, is there a claim? And then they have to make sure that the amount of inheritance tax is paid and that it is paid timely. So how do you choose an executor? Well, you want a responsible person. This is really a job. You know, an executor can take a commission, percentage of probate assets. So they need to do it. You can name a bank or a trust company. We'll talk about that in a second. As I said, you probably, when you list in your will, at least one younger successor. If you're not choosing a bank or a trust company as your executor, choose a backup that is younger than you. And proximity. This can go either way. It really depends upon your assets. It's easy, it's fine. It takes just a little bit longer to have an executor in another state. But if your estate consists of lots of real estate that's going to have to be opened and safeguarded and cleaned out, and somebody needs to be doing it, somebody closer may be a better option. Again, this is where things are different for every client. You want a drama-free person to be your executor. So if you already know, if you have several beneficiaries where there might be some hard feelings or something like that, corporate executor may be the way to go. For example, we often have many estates where one of the children cared for the parent, and the parent in their will left them a little extra. as a way to thank you. Well, the other child in another state who wasn't caring may not be happy about that things aren't equal. So you don't want the caregiver child to be the executor and have to deal with the sibling from another state being upset. So again, look at your own situation. And the other positive for a corporate executor is there are final personal and fiduciary tax returns that have to be made that we often see that individuals make mistakes if they choose to do them on their own. These days there are more second or third either marriages or relationships with children from prior relationships, and that even if you would want your current spouse to be the executor can be a little bit uncomfortable if you want the money to your children to be held in trust. And so really a lot of positives to having a corporate executor. And corporate executors also have processes in place that they're going to make sure that something is not sold at the incorrect price. What if no probate assets? Well, you might say to me, what does this have to do with what's the difference between a POA and an executor, and do I need them both? Well, I have to tell you, I've frequently been asked this question. I don't need a will, so I don't even need to think about an executor. I have it all figured out. I own my assets jointly with somebody, or I have beneficiary designations in place, or TOD, transfer on death, or payable on death designation. So when I die, it's all going to go to the right people. We don't even have to open in the state. Well, what I usually say is you should. Here's why. Sometimes the people that you co-own things with or that you have listed as your beneficiary, you may pass away together. It may be a common accident. Or they may have died and you just forgot about going in to update your beneficiaries to put somebody else on as the person to receive it. And often, and not often, I've had it happen a few times, there's the surprise inheritance from somebody. I had one case where the client had been aging and wasn't doing very well, and upon death had found out that when we were looking at the estate, that the neighbor down the street for whom my client had always shoveled the walk and the driveway and the like had remembered my client in their will and given them money. So you just don't really know. So you should always have a will and a power of attorney. So as a conclusion, everything is different. We should talk about it, have a power of attorney for healthcare and finances. Think about it very carefully. Talk to them. There could be some pre-screening. You do need an executor, and remember that circumstances do change. It could be as much as somebody passes away, somebody new is born, somebody becomes 18, you inherit a lot of money. We recommend that if there's a significant change in your life or your opinions on who you want to serve for you, you should update. But at least look at it once every 5 years if there's a significant change. All right, I'm looking to see if we have any questions. I do not see any currently. So what I will say is thank you very, very much. It has been a pleasure with you today. You can always go to our website, as I mentioned, paelderlaw.com. Many blog articles and information and resources. And if you want to see other YouTube presentations, again, go to our homepage at paelderlaw.com, scroll all the way to the bottom, and there's a box that says View Past Webinar Recordings. Thank you very much for joining us. Take care.